All right, welcome, KSLU students, to today's explainer lecture. Let's settle down, sit up straight, get your pens ready, and prepare to take some absolutely meticulous notes. Today, we are dissecting question 21 from your syllabus, the procedure and importance of succession certificate, probate, and letters of administration. This is a high-yield topic, and I expect you to master the exact structure I'm about to lay out for you. Let's begin. Okay, here is your synopsis. 1. Introduction to succession. 2. Part 1, Succession Certificate. 3. Part 2, Probate. 4. Part 3, Letters of Administration. 5. Landmark Case Laws Analysis. And 6. Conclusion.
Right, heading number 1, Introduction to Succession, Statutory Foundation.
Under the Indian Succession Act, 1925, when a person dies, legal authority is required to deal with his property. This is done through 1. Succession Certificate, 2. Probate, 3. Letters of Administration. Now listen to me carefully. Write this heading clearly in capital letters. This must form the primary introduction block of your 16-mark essay answer. Don't just skip straight to the definitions, okay? You have to set the statutory foundation first. The law absolutely abhors a vacuum. When a person passes away, their assets can't just sit in limbo, and no one can just claim them arbitrarily. The state demands absolute legal authority to deal with this property. So I want you to heavily underline Indian Succession Act 1925 on your answer scripts. If the KSLU evaluator doesn't see the statute year in your very first sentence, you're going to lose marks immediately. It's really that simple.
Moving on, heading number 2, Part I, Succession Certificate.
Point 2. Meaning. A certificate granted by a court to the legal heir to collect debts and securities of the deceased. Make sure you write this exact subheading clearly on your answer scripts. We are going to address these 3 mechanisms one by one, keeping them strictly separated. Now, pay attention to the classroom explanation here. A succession certificate is not some magic wand for all property. No, it's strictly and uniquely limited to 2 things: debts and securities. So if there's a bank balance, a provident fund, or shares in a company, this is your tool. Take your highlighters right now and highlight the words debts and securities. Do not write about immovable property like land or houses in this section. The evaluator will dock marks if you confuse this scope.
Next, let's look at the procedure. 1. Application filed in district court. 2. Contains details of death of deceased, relationship of applicant, debts or securities. 3. Court issues notice to interested parties. 4. After inquiry, certificate is granted. Okay, in your exam booklet, you must write this exact procedure in a step-by-step flowchart format. Draw the arrows. Literally show the progression from the district court application down to the inquiry. Doing this visually secures maximum marks for sections 372 to 381 of the Act. Don't write a dense, boring paragraph. Give the KSLU evaluator a clear, procedural flowchart.
Now, point 4, importance. Provides authority to collect debts, protects debtor who makes payment in good faith, facilitates smooth transfer of assets. The second point here is absolutely crucial. If a bank pays out the deceased's money to the holder of a succession certificate and it later turns out another heir had a better claim, well, the bank is completely protected from liability. This protection of the debtor making payment in good faith is exactly what the KSLU evaluator is looking for. Explain this in 2 strict sentences in your paper. All right. Part 2, Probate. Official proof of will.
Point 5, Meaning. Probate is the official proof of a will granted by a competent court. Prepare yourselves for the second major statutory pillar of this answer and ensure your structural format is rigorously maintained. Listen to me very clearly on this. A probate is strictly, absolutely, and uniquely for cases where the deceased has actually left behind a valid will. If there's no will, there's no probate. In your notes, I want you to underline the phrase official proof of a will. Look, a will is just a piece of paper until a court affixes its seal and certifies it. That seal is the probate, and stating this demonstrates precise legal knowledge to your examiner.
Let's review the probate procedure. 1. Application filed by executor named in will. 2. Submission of original will. 3. Court verifies authenticity. 4. Notice issued to interested persons. 5. Probate granted if will is valid. Now, coach yourselves to number these sequentially on your exam script. No bullet points here, use numbers. I really must stress the vital importance of step 3 here, the court verifying authenticity under sections 222 to 263 of the Act. The court is actively checking for fraud, coercion, and the sound mind of the testator. You must mention these sections prominently. Point 7.
Importance. Confirms genuineness of will, gives executor legal authority, prevents disputes. So why is this so important? Let me expand on that final point. When an executor has probate, their authority is absolute against all the world. This immediately silences bitter, drawn-out family disputes where, say, a distant relative might suddenly produce a fraudulent secondary will. Giving the executor immediate legal authority stops frivolous litigation right in its tracks. This is absolutely a point worth expanding upon in your exam script.
Moving on to Heading 4, Part 3, Letters of Administration.
Point 8. Meaning. Granted when no will exists or no executor is appointed. You have got to clearly distinguish this mechanism from a probate. Remember, probate is when there is a will and an executor. Letters of administration come into play under the dual conditions of either complete intestacy, meaning the person died without a will at all, or a situation where there is a will, but the deceased forgot to appoint an executor or the executor just refuses to act. Make this distinction crystal clear for the evaluator.
The procedure here: 1. Application by legal heir. 2. Court examines claim. 3. Notice to interested parties. 4. Grant of administration rights. Do you notice the difference here? It's not an executor applying. The legal heir must step forward. Guide yourselves to present this as a precise procedural sequence on the page. The court evaluates who is most fit among the legal heirs to administer the estate before granting these rights.
Point 10. Importance. Enables management and distribution of estate. Ensures proper administration of property. Why does this matter so much? Because the proper administration of an intestate property is absolutely vital for maintaining legal order. Without an appointed administrator, heirs are just going to illegally grab assets, tenants won't know who to pay rent to, and creditors will file endless suits. The letters of administration centralize the power, thereby avoiding massive civil litigation.
All right, Heading 5, Landmark Case Laws Analysis.
Krishna Kumar Berla v. Rajendra Singh Lodha discussed probate proceedings and validity of will. Now, I demand your absolute attention right now. Drop your pens. This section is exactly where you upgrade an average, passing answer to a top-tier distinction mark. The evaluator is waiting to see if you actually know the jurisprudence. So Krishna Kumar Berla versus Rajendra Singh Lodha discussed probate proceedings and validity of will. Now listen to this mandatory deep dive. The brief facts: this massive litigation involved the multi-crore estate of Priyamvada Berla, who allegedly left her entire estate to an outsider, her chartered accountant R.S. Lodha, entirely cutting out the extended Berla family. Naturally, the Berla family challenged the probate. The ratio decidendi, the final verdict of the Supreme Court, firmly established the concept of cavitable interest. The court held that only a person who has a real, tangible interest in the estate, meaning someone who would be entitled to a share if there were no will, can actually challenge a probate proceeding. The absolute relevance of this case is that it defines the strict boundaries of locus standi in probate law. It prevents strangers or distant relatives with no real claim from holding up the administration of an estate out of sheer nuisance. Here is your exam tip. I instruct you to draw a literal box around this case law in your exam script. Write it, box it, and explicitly state the phrase cavitable interest to capture the examiner's eye.
Next case. Madhvi Amma Bahamani Amma vs. Kunjakutti Pillai Minakshi Pillai. Clarified nature and scope of probate and succession proceedings. Here is the full breakdown. The dispute here centered on whether a succession certificate acts as the final word on who actually owns a property. The Supreme Court established a crucial ratio here. Proceedings for a succession certificate under Section 373 are purely summary in nature. The verdict clarified that the grant of a succession certificate does not finally determine the legal title or ownership of the property. It merely gives the grantee the temporary authority to collect debts to give valid discharge to debtors. If there is a deeper dispute about true ownership, well, that must be decided in a separate, regular civil suit. Why is this absolutely relevant to your syllabus? Because it legally separates the procedural tool of debt collection from the substantive right of property ownership. Reminding you once again, highlight this case name in a separate boxed format to immediately capture the KSLU evaluator's attention for that full 16-mark answer.
Finally, Section 6. Conclusion. Succession certificate, probate, and letters of administration are essential legal tools to ensure orderly transfer of property after death. They provide legal authority, prevent disputes, and ensure proper administration of the estate. Instruct yourselves to pen down these exact final thoughts. You must bring your answer to a decisive academic close. Do not just stop writing, conclude your argument. Succession certificate, probate, and letters of administration are essential legal tools to ensure orderly transfer of property after death. They provide legal authority, prevent disputes, and ensure proper administration of the estate. Writing this succinctly and neatly ties the entire KSLU answer together, covering all three statutory mechanisms we discussed today.
It hits the exact keywords the evaluator looks for. Now I'm going to leave you with this strict, provocative question to ponder. If we did not have these exact, rigorous procedures under the Indian Succession Act, what absolute chaos and unending generational warfare would consume our civil courts? Think about that, structure your answers flawlessly, and you will secure your distinction. Class dismissed.